Well, good morning, everybody. Thank you so much for joining us for our July webinar in our Family Caregiver series. I'm excited for today's topic and to introduce our speaker to you in just a couple of minutes as we talk about the importance of an up-to-date estate plan in the age of COVID-19. So definitely a very relevant topic for today. So before we get into that, I do just want to stop for a second and let you all know that we are wishing you and your families all the best during this time. This has definitely been a challenging past about 4 months or so that we've really seen the effects in our community. And I just hope that all of you are staying safe and healthy and your families are doing well. A little bit about ElderHelp. So we are a local nonprofit organization and we support seniors and family members in our community through a variety of programs and services. We have been supporting seniors in our community for over 46 years now, and we have really wanted to aim at reducing social isolation, increasing access to healthcare, and improving overall quality of life. So the programs and services that we typically provide include information and referral services for people who are looking for resources in the community to better help their loved ones or themselves. We also offer Are You Okay check-in calls for clients who are looking for just somebody to check in, make sure they're doing all right. It also offers family a peace of mind knowing that there is somebody checking in on their loved one on a daily basis. We have a transportation program called Seniors A Go-Go and our care coordination program where we have social workers assessing the needs of our clients, but also volunteers who are at the core providing very necessary services for our clients to be able to stay independent in their own home. We offer senior housing services through our housing consultations, as well as support to 2 low-income senior buildings in the county. And our family caregiver program, which is where this webinar is through. We offer mostly online support for family members who are caring for a loved one at any stage of that journey. So whether it's somebody who might be worried about a loved one and trying to figure out what the future might hold, planning ahead, or in the midst of day-to-day care and looking for resources and support during that part. So we offer webinars on a monthly basis that cover a variety of topics, and we also have created 5 online courses that are all available through our website for family members to help guide them through that journey. So we're very excited to be able to offer these webinars online to all of you and share very valuable resources and information. So I am very honored and have the privilege of introducing to you our speaker for today. So Yvonne Amrine, she is the founder of San Diego Planning Partnership, a 501c3 corporation dedicated to educating San Diegans on the importance of estate planning and long-term care. Ms. Amrine is licensed to practice law in the state of California. She is a member of the National Academy for Elder Law Attorneys, where she serves as the board president of the Southern California chapter. She is accredited by the Veterans Administration to represent clients before the VA Regional Office or the Board of Veterans Appeals and Practices Estate Planning and Elder Law through the county. She is dedicated to serving the older adults of San Diego and helping them plan for their future. And Yvonne, we're just so excited to have you here sharing your wealth of knowledge and information with us today. So thank you so much for being here, and I'm gonna pass the controls over to you.
Great. Well, thank you, Carrie, for having me here. And let's make sure that I know what I'm doing with the slides here. Is it, I see you doing something.
I haven't touched it. Hopefully it'll advance for you. Yep.
Okay. Let's see if I can go back. No.
And I
Well,
forgot to
there you
mention
go.
before you do get started, Yvonne, that
Yes.
if anybody has any questions, what we plan to do is open it up at the end for you to ask your questions. You would need to submit them through the raising of your hand feature, and you can type in your questions through that. So just in an effort to have that done at the end, I just wanted to mention that.
Great. And thank you, Carrie. And I really want to thank ElderHelp for having me here today. I want to take a couple of minutes to talk about San Diego Planning Partnership. You kind of heard my bio and the fact that I founded this back in 2017. And it was kind of a tap on the shoulder. My mom had passed in 2016, and I guess I needed something else to do, right? But I had a long journey with her, and I'll tell you a little bit more about that in a moment. But San Diego Planning Partnership is really bringing together a group of professionals that help the senior and the caregiving children in community. We are those that help you to sell a home if it's needed. It might be a situation of needing to get caregivers in the home, those types of things. So professionals that I have grown to know over the last 10 years or so in my law practice, and finding a way to get this education out to the community that is unbiased. So they're not allowed to bring in their sales pitch and talk about how great they are. They are here to educate you in a way that you can make decisions that are right for you. So that was the birth of San Diego Planning Partnership. We did live 2 morning workshops for all of 2018 and 2019. And we even had one in January, January 30th of 2020, live in person. So as you probably have guessed, we haven't had anything in person since March. And so we've taken this information online, and we are now recording these as webinars, much like what you're watching today. And so if you want to go to sd-pp.org, you'll find you can register for some upcoming talks we're having. The next one we have coming up is going to be from the PACE program, that's St. Paul's Senior Center, Senior Services PACE program. And they have had to change the way their whole system works because of COVID. As you can imagine, the senior centers are also not running right now. So pop over there at the end of this and see if that is something that might interest you in learning more about how you can qualify for that program. So I am, I know Carrie gave my bio, and so I'm not going to go into a lot of detail about that. You can read the slide, right? And one of the things that I am honored to say is that I am president of the Southern California chapter of NALA. That's the National Academy of Elder Law Attorneys. And I have been in that chapter since I started my law career in 2011. And they've educated me on the difference between estate planning and elder law. And there are big differences in the way I write my plans versus the way an estate planner does. So I'll be talking about that a little bit throughout the presentation. That's why I want to make note of that. But the most important credential I have on this is that photograph. That is my stepfather, Paul, and my mother, Norma. They had been in the same church for 50 years. Paul lost his wife, Pauline, to a brain tumor. My mother had been the Stephen minister that had come over and given her communion and checked in on her on a weekly basis, and really helped to make sure that she had a connection to their church community that they'd both been in for 50 years, right? So after Pauline passed, my stepfather asked my mom out for breakfast. And so they were married in 1998. And the reason that I ended up going into elder law so late in life, I actually got my law degree in 2010, and I'm not a spring chicken. And it's really because of my experience with my stepfather and my mother, Norma. My stepfather died about 5 years after they were married, and he made sure, because he knew, actually right after he had proposed, he found out he had non-Hodgkin's lymphoma, and he knew he had about 4 or 5 years to live. So he put a really good plan in place. He went to an elder law attorney in Arizona, and we had many conversations, Paul and I, because he had named me as the successor trustee, and my mother had named me as her agent under healthcare power of attorney and finance. So I know what those adult caregiving children are living through out there in a lot of cases, and it is definitely something that you don't come to naturally, and there's a lot of education to be had. So thank you so much for ElderHelp in being able to be around San Diego for the last 45 years to help you with that information. And so they really are the basis of why I do what I do. My mother was diagnosed with Alzheimer's in 2003. I noticed it in 2001. I actually noticed it a little before my stepfather passed later that year. And it took a couple of years until we got a diagnosis. But after we got that diagnosis, we also started having more conversations, and you're going to hear me talk about conversations a lot today. So with no further ado, I am going to get into the presentation and talk about what we're going to talk about here today. So this is the course outline, and you know, we're going to talk about planning for incapacity. And the reason that we start there is because there is a 70% chance that you will need help and long-term care. You'll need to access long-term care benefits before you pass. 70% of us do that. Not all of us die peacefully in our sleep like Dick Enberg did. I don't know if any of you are Padres fans, but in the latter part of his life, he was the announcer, and he just didn't get up to get on that plane the next morning. So that doesn't happen to everybody. A lot of times we do have debilitating diseases such as Parkinson's or Alzheimer's or MS or some other disease that doesn't shorten our life, but it does mean that we need an extensive amount of long-term care, and that it's not always going to be a situation in which the children can take on that burden completely, and you're going to need help. So we're going to talk about planning for incapacity. We're going to talk about quality of life and what does that mean to you. We're going to talk about the personal and financial decisions that need to be made during those times of incapacity, and how you can put your communicate these things, put them on paper in a way that is recognized by the state of California, and allow that person that you trust the most to make those decisions for you. We'll talk about those key components of the estate plan and how they work together. So, you know, since COVID-19 has become a reality for all of us, I think we're all taking some extra time and slowing down and getting to that to-do list, because, you know, for quite a while we couldn't leave home at all, right? So, and if you're over 65 or you have a chronic health condition, you're still staying at home and staying safe. So it's a time for us to pull out that estate plan if we have looked at it or put it in place, and take a look at it. I always say decade. If you haven't looked at it in 10 years, you probably need to go back and read through it, maybe make it your bedtime reading so that you have something that will put you to sleep, but also make notes about what's changed in your life since you did that plan 10 years ago. Are those agents still available to be able to act for you if you can't act for yourself? So decade is a good reason to take a look at it. Divorce or marriage is another good reason to take a look at that plan. Disability or change in health is another good reason. And then, of course, if one of our loved ones die, we also need to take a look at that plan at that time. So as an estate planning attorney, I'm busier than ever right now, but it's much more difficult, and it's taking a lot more time to get the plan in place because we have no in-person meetings right now, or haven't for a long time. Up until recently, we didn't have a protocol for being able to meet with people in a closed office environment. We do have that now, but it's still a very personal choice as to whether you want to leave your home and take the risk that you might contact the the COVID-19 virus along the way somehow. But it's something that you really need to think about, making sure that these documents are up to date. And so what I'm going to point out, which is different than what I used to talk about in the live setting, is which documents you can get done today on your own by printing them off of the internet and signing them, and what you need to do to have legal witnesses work for you instead of needing a notary, which would mean either having a mobile notary come to you, or it would mean going to a postal annex or you know, some other service that would be able to notarize those documents for you, or possibly coming into your attorney's office. Right, let's see if this slide is going to change for me. It's a little slow. All right, so the first thing that we talk about in all of this is capacity. So, you know, if you watch a lot of TV, you'll see that people get deemed to be incapacitated or not have capacity in the legal sense of the word. They can't stand for trial. That's not what we're talking about here. What we're really talking about is the ability for them to make an informed decision. And that's in that moment that they're making the decision, that they understand all of the ramifications, the risks of making that decision, the outcomes of that decision. And that's usually done by a doctor or an attorney. When you come to my office, I'm going to make sure that your memory is good, that you understand who the bounty, who would receive your bounty if you were to die. That's actually a legal term, comes back from England. So those certain things that you need to understand, how much you own, what's in your bank account, all of those types of things. But there are different types of incapacity that can occur that would make you not able to sign those documents at that time, or make you not able to make a medical decision at that time. It can be temporary. When it's temporary, it's something like an episodic mental illness might occur, or it could be substance abuse. Maybe you're under the influence of a drug or alcohol. Or it could be a sensory loss. If you go to the doctor and you forget to bring your glasses and your doctor gives you something to read, you might not be able to comprehend everything. You might leave your hearing aids at home. That would be a problem as well. You wouldn't be able to communicate, hear your doctor, or communicate. So that would be a situation. Another situation would be delirium, and that could happen because of a health condition such as urinary tract infection, something like that. That happens quite a bit as we get older. That happens to be one of the things that can cause that to happen as a temporary basis. There are irreversible and ongoing issues that can come up, and those are going to be more of a persistent mental illness, and it could actually be an intellectual disability that you've had from birth. So some of those types of capacity issues are irreversible, and they may mean that you can't sign a document. So if you get a diagnosis such as Alzheimer's or Parkinson's, and Parkinson's does have a dementia that goes along with it, and then also the ability to not communicate, you're going to want to make sure that you take a look at your plan early, and that you start to have conversations with those that love you and those that you trust to be able to carry out your decisions. So that's why I really start with this capacity slide. And it comes from a very long and very detailed presentation that one of our founders, our founding board members, Amy Abramson of Alzheimer's San Diego, put together. So I give her credit for pulling that together and being a part of San Diego Planning Partnership. But she really is an expert in this area. So what we're trying to do is we're trying to plan for incapacity, because if we don't plan ahead for incapacity, then we're going to have to turn to the probate court to make that decision. They're going to ask your doctor to fill out a a form that says that you no longer can make these decisions, and it has categories and things that you can understand and not understand. And then they're going to deem you incapacitated for the purposes of making your own decisions for your life throughout the rest of your life. So let me see here if I can get this to move ahead. There we go. It's working. So key concepts in advanced care planning. You know, it's a bell curve of life, right? We need help on the way in from our mothers and our aunts and uncles and grandparents. I just had a grandson February 2nd, and I can tell you I was really enjoying holding him up until COVID hit, and we had to separate because we're not in the same household. So that was a difficult time to go through, but I digress. That curve of life, it also happens on the way out. And you know, there are 70% of us that are going to need that help from a loved one or from a caregiver. And sometimes that job is so big that you really do need outside help. And so we want to make sure that we have the right documentation in place and the right triggers in place to know when we need to do that. And we're going to plan for autonomy and keeping dignity, but we can't always plan for independence. It might mean at some point that you're not going to be able to take care of yourself, and maybe your parent, you're not going to be able to take care of your parent by yourself. And so we want to have those triggers in place that allow our children or our loved ones or spouse or some other professional, if the case is that you don't have children, can make those decisions for you. So we're going to ensure that your needs and your preferences and your values are clearly understood, and understood by those people that you've named to be your advocate. To do that, it's going to require some reflection on your part. It's going to require some legal documentation be put in place, and it's going to require that you communicate. And I have to say, one of the things that I hate to hear is when I get the call that says so-and-so is in the hospital. I didn't know I was named as their agent under healthcare power of attorney, and I got the call at 1 in the morning. That's not how we want to find out. We want to have conversation, and that conversation is going to give your plan much more meaning. So that is something that you'll hear me talk about quite a bit as we go. I also like to point out my own personal story here too. We planned ahead for my mother, Norma, and we had many conversations after she had her diagnosis of Alzheimer's. We had conversations about when it was going to be okay for her to leave her home, because she was always one of those people that said, "You're taking me out feet first," right? She wanted to live at home for her entire life. She did not want to leave. We had conversations about having her move from Arizona to California. She did not want to do that. She thought California was cold. She grew up in the Sacramento area, and she just remembers a lot of rain back then. And so she didn't want that. She wanted to stay in Arizona. She wanted to stay with her little dog, Roxy. And so for 4.5 years, we were able to do that. But she said, okay, when I don't know that the way to my own bathroom in my own home, then I'm going to be okay with moving. And so it was that moment, actually, that she stood up and she didn't have the word for bathroom any longer. And she said, "Where do I go?" That I knew it was okay to make that move. So, we all have to have these conversations so that we can make those tough choices and know that we're making the right decision for our loved one. So what conversations are we going to have? What does that reflection piece look like? This is also another piece of Amy Abrams' conversation that she has in San Diego Planning Partnership, and I'm sure she uses it in other places that she talks. There are multiple dimensions to your quality of life. It's physical. So, I used to be able to ride a bike 100 miles in a day. I'm lucky if I can do 20 miles right now. My hip hurts when I get on the bike. So, what was a good quality of life and what did a good day look like back just 5 years ago was being able to get on a bike and take the weekend bike rides with my husband. That's not happening anymore. So now I have to redefine what that looks like for me. There's an emotional, intellectual, spiritual, and a practical sense to what that good day looks like. So you need to understand what your personal definition is. It's okay that it's subjective. One of the things that is important to start thinking about is your end of life wishes. And so that might change for you. Even your end of life wishes might change for you over time. But it's good to communicate that to your agent so that they know what you want. And it needs to be written down in a way that can be legally recognized. But don't assume that your advocate knows your health history, for instance. It was many years before I understood that my grandfather had colon cancer and that my mother had a propensity for colon cancer. She had already had a bout of breast cancer earlier in her 50s, but little did I know that there was this history that I now need to be aware of. But most importantly, that we had to get her checked for colon cancer more regularly than we would have if she didn't have that family history. The other piece that comes to mind is she's allergic to sulfa antibiotics. So if I wouldn't have known about those things, if it wasn't written down somewhere that you could access it, or we didn't have conversations about those things, then I wouldn't have known how to best take care of her. So also, when it comes to what's important for you and what you want at your end of life, we had long conversations that really helped me to know she knew the reality of how much she had, what we had to support her. And she knew that she probably wasn't going to be able to stay in her own home forever because the cost of care is very expensive when you need 24-hour care. You're not willing to move in with a child, that type of thing. And, the stress that would put on. She just did not want that burden to happen for her kids. So she wanted to stay independent as possible, but with autonomy, I guess I should say, and having caregivers brought into the home. It was those conversations that allowed us to make those decisions. So now let's talk about the documents. The first one is the Advanced Healthcare Directive. Other states may call this a living will, but what this document does is it appoints your agent. And you want it to be durable. What does that word durable mean? That word durable means that it's going to live beyond your incapacity, meaning that as soon as you become incapacitated, it doesn't die. So, or become invalid. So that word durable is very important. It may be that it has a trigger in it as well, and that trigger would make sure that you make all the decisions you can make up to the time that your doctor says you can't make those decisions for yourself any longer. Then they're going to access your agent under that power of attorney. It gives that agent the authority to access your medical information. And that is through a HIPAA form. And we'll talk about that in a little bit more here in just a few minutes. There is a statutory form of this Advanced Healthcare Directive. And you can download that online at the California Secretary of State website, I believe has a copy of that. And also the ABA website has that. That's the American Bar Association. Make sure you use the California version of that statutory form because it is, there's a different way that that is carried out. It can be witnessed. It doesn't need to be notarized. I notarize the ones that I do for my clients, but you can download this document and you could get this document in place today. But those witnesses cannot be the named agent. And I also say, with other documents that we'll talk about, having a family member sign that is probably not a good idea, but your neighbors could do it for you. And even socially distanced, you could call your neighbor on the phone and have them sign the document out on the patio, something like that, where you're socially distanced. And usually these have two witnesses. Let's see if there's anything I missed. The statutory form, however, does not include the HIPAA. A customized document that you would get from an attorney does include a HIPAA waiver. So a HIPAA waiver would have to be done separate from that. We'll talk more about that in just a moment. So what types of information can be included in the Advanced Healthcare Directive? This is going to be the life supporting measures that you want. So it's your end of life wishes. The statutory form is limited to two choices, either prolong my life or don't prolong my life if I'm in a coma or a vegetative state. I don't want to be intubated, that type of thing. It will also have information about pain medications and other comfort measures, sometimes called palliative care. So that's something that's important to think about at the end of life. It will also, you can outline your personal care wishes there. Now, your wishes in a legal document are really just wishes. So you're saying what your likes and dislikes are and what you might want. If you have specific music you want played when you are in hospice or something like that, you can put that in that document. It isn't always practical in some situations. So, have those conversations with your loved ones and make sure that not only are you capturing it in that document, but that you're having those conversations about what your preferences are. The other piece that's important is there's specific language to preserve Medi-Cal and long-term care benefits through the state. And those are done in a customized document that you would get from an elder law attorney most times. Estate planning attorneys more and more are putting that document or that language in theirs as well. The instructions at the time of death are also included in that Advanced Healthcare Directive. It might be that you want to be an organ donor or a body donation. Might be listed there, and that your disposition of remains can also be listed there. So now let's talk about the HIPAA waiver and some of the important other key documents that come into play. So every time you go to the doctor, you sign that you have read this HIPAA waiver. Or the HIPAA regulation, actually. You have the ability to let your doctor know who you would allow to call and access that medical information, that protected medical information. That is specific to that doctor or that hospital or that medical clinic that you're going to. It does not work for you to take what you signed with that doctor and take it to the hospital, for instance. So you can imagine if you don't have a HIPAA form that is separate from what you would fill out in a doctor's office or a hospital or medical clinic, then that information is not going to be easily accessed by those that you want to be your agent. So that's number one, and that's a point that you should take note of, is make sure you have a good HIPAA waiver in place. So let's see, I'm going to do a few graphics here because maybe some of you have seen this form. This is printed on bright pink paper. And it's called the Physician's Order for Life-Sustaining Treatment. And I am sure that if Amy Abrams has done a couple of presentations here, she's talked about this as well. This actually becomes part of your plan, but it's different than the Advanced Healthcare Directive. It actually works alongside of it. It is an order, a doctor's order. And what I want to say about this document is if you have a chronic condition, health condition, or a terminal condition, you want to sit down with your doctor and have your conversation about what you want at the end of life in the way of nutrition, in the way of comfort, in the way of end of life measures, so that it becomes an actual order that follows you, the person, anywhere you go. And it becomes part of your medical record, right? So the difference between this HIPAA not the HIPAA waiver, but the POLST form and advanced healthcare directive is. That advanced healthcare directive is a legal document, and if the agent had some issue with the medical providers, they would have to go into court to make sure that it was actually honored in the way that and you as the agent had the ability to make sure that your loved one's wishes were actually followed by that doctor. So there's another thing that some of you may have also heard about, and it's called the Vial of Life. This is not the one that we use here in San Diego County, but I couldn't find a picture of it. Maybe next time I'll take a picture of one that I have as a sample. But what it does is it's a sleeve that's usually got a magnet on the back, and it's usually kept around your refrigerator, on your refrigerator. If you've got caregivers in the home, they might have it in another place where they can easily access it. It would have a copy of your advanced healthcare directive. It would have a copy of a HIPAA waiver in it, and it would also have a POLST form. The one that you can get through Health and Human Services here in San Diego, it has a sticker that goes on your front door so that if the emergency EMTs come to revive you, they are going to know exactly what you wanted. If you don't want to be taken to the hospital, they'll know that. So those are all important things to have in place. So again, I'm going to talk about communicating your wishes. You want to have these regular conversations as your health changes, and you want to make sure that if you've named someone to be an agent or an alternate agent even, that you ask their permission. Like I say, you don't want them to find out when the phone rings at 1 o'clock in the morning. So you want to make sure that they know your medical history. I talked about that as well. And then you want to share in a way that's comfortable for you. See if I can get to the next one. I think, I might have skipped one. Yep, I did, so sorry. All right, so it's not going the right direction here. Let me see if I can get it going back. Hello, Carrie, I might need your help. It doesn't seem to be going backwards.
Oh, okay. Is it?
It won't reverse. Yeah.
Okay, let me see.
There, see, it wouldn't even highlight those. I think I can. Nope.
Do you want to go back more?
Yeah, a couple more, I think. And click one more time just to see if nope, okay, we're good. I think I got it.
Got it? Okay.
Yeah, technology, the world we live in. So the second most important document in your plan is a power of attorney for financial management. This is a written, and it must be notarized legal document. There is a statutory form of this as well. And you can also download that either at the Secretary of State's website or through the ABA, that's the American Bar Association's website. Make sure again that it's specific to California, but it must be notarized. So this gives, you are the principal in this if it's your document, and you are giving authority to your agent to manage your financial. They can get into your bank account, they can write checks for you. One thing I will say is banks no longer allow, even though the document may say that that agent can open a bank account for you, banks are not allowing that. So they're making up their own rules. And sometimes this can be a very problematic document to work with if they are not, your bankers are not familiar with who you have as a named agent. So if you do get this financial power of attorney in place and you know your banker, which these days it's much harder to get to know specific bankers at our local banks, make sure that if you need to have the agent on your account, that you take the document in with that agent present, and they will help you to fill out their own power of attorney form for financial management. Banks are very picky about these, so I like to make that known. It deals with your property and financial transactions. If it has real estate that it deals with, you want that agent to be able to sell your home, for instance, if you needed to go in and use those funds to pay for care or move to another state or something like that. You would want to have that actually recorded with the county. Because it could be turned down by the title company and it would be a problem. There'd be a lot more difficulty trying to get that house sold if it wasn't recorded. But it can help with banking. It can help with that agent can sign your tax return. They can also apply for public benefits. And we have great Medi-Cal benefits here in California and specifically in San Diego, a great complement of benefits that you can get. And then it also could have language that would allow gifting to happen in the manner that you had actually been doing during your lifetime. So if you are tithing, for instance, and you don't have a financial power of attorney in place, when that agent takes over, they are not going to have the ability to continue your gifting to your church or synagogue or mosque. So something to think about there. Also, another thing to understand is we'll be talking about trust here in a moment. It does not cover trust that's titled in the name of your trust. You know, if you have your home titled in the name of your trust, that trustee person, hopefully it's the same person as your agent under financial power of attorney is going to be able to do that. Again, it needs to have that magic word durable so that it can be effective after you've lost capacity. And the thing to understand about this is it terminates when you die. So if they're managing your bank account during your lifetime, at the moment of your death, once that death certificate is reported, then that agency relationship between the principal and the agent is no longer valid. All right. So now we've talked about, and we're going to go through the rest of these. We've talked about the Advanced Healthcare Directive. We've talked about that important HIPAA authorization or HIPAA waiver form and the powers of attorneys, right? So now let's talk about the will, which you all got a sneak peek at my slide there about wills and trusts. And then, you know, we're probably not going to have time to talk about much with life insurance, retirement, and investment accounts, except to say that your estate can pass by transfer on death or pay on death beneficiary designations, and that's perfectly fine too. You do want to make sure that you keep those up to date. Sometimes they get lost in the huge consolidation of banks. We found that those records were lost for people, and so that property ended up going to their estate, and then we had to open probates for just to be able to transfer that property. So make sure that you check that. Assignments of property are part of a plan, and also spousal property agreements for a married couple can be part of that plan. So a will is a written legal document. It can be signed by the testator in front of two witnesses. What is a qualified witness? A qualified witness is someone who is not named in your plan, so they can't be a beneficiary of your will. And so that, you know, and they can't actually benefit even if they're a spouse of someone who's named in your will. So you're going to need to get together with a neighbor or a friend, or maybe your pastor, someone like that, that can be that witness for that will. If all you need is a simple will, you can also find the statutory form for that. Those two places, American Bar Association, and I believe actually our California court systems might have that one in statutory form that you can download as well. So you might want to take a look for California statutory form will and download that. It names an executor. So that that agent in power of attorney was the person that managed things during your lifetime. Hopefully it's that same person that becomes your executor after you die that's going to manage your estate and make sure that your wishes that are written down, everybody gets the property that you designate in your will, that you want to have the bounty or the, all of the assets that would be part of your estate. That person can also name, you can name a guardian, which could either be that executor or somebody else. It also provides for funeral and burial instructions. You may recall with the Advanced Healthcare Directive, I talked about you can have burial instructions there as well. And it's appropriate to have those in both places. It can also name an asset custodian for those people that are under 25. So if you have grandchildren that are going to inherit, you might not want them to get a large amount of cash right away. You might want to have those in an account that would be a custodial account until they turn age 25. The good thing about this document is that it can't change after your death, so your wishes must be honored. And what it does is it distributes all of your property. Let's see if there was anything else I wanted to say about this. Well, I guess I have to say something about the picture there. The reading of the will and the dark and stormy night that we used to see in the movies, that doesn't happen anymore. This is a very court-intensive process, and it actually is more expensive than doing an estate plan with a trust in place, because you do have, in addition to the expense, you have the condition of time. And during COVID, we had about 600 probate cases that were delayed, and now those have been scheduled out, and the court is trying to now manage all of the other cases that have been coming in since the court was shut down. They opened up again, I want to say it was late May, it might have been early June. So they are taking cases, but they're socially distancing, and it's taking a lot longer for things to get through probate court. So the one thing you want to try to do is avoid probate if you can. And so that takes us to the next slide. Does a will protect your estate from probate? It doesn't. You would still have to go through that probate process, which is why trust law has grown up and is more accessible to everyone, so that you don't have to go through probate. Also, another thing I'd like to make a point is you want to make sure you have an original will. Because if you don't, then that it will need to be proved that it wasn't revoked, and there are some steps that have to be taken to do that. Also, don't write on the original of your will, and this is the only document in your plan that you actually have to have an original of, although banks will tell you they want to see the original of your trust and they want to see the originals of your powers of attorney. But this one, absolutely, the court needs to see an original of. If they don't, then you write on it, even, it can invalidate your will. So now let's talk about trust. And here's what I try to make a little bit more fun is talk about maybe some TV families that you're all interested or maybe know from watching TV over our lifetimes. Maybe some of you are too young to have remembered this couple, but this is Joan and June, I think it was, and Ward Cleaver. Leave It to Beaver was the show. This was the typical nuclear family back in the day, and this plan was basically everything goes to my wife and then it goes to my children after my death type thing, or my wife, because we're, we still, back in the day, men had much shorter lives than women, and I think it's still probably true today, but it's really a very simple plan, but it does allow you to avoid probate. We have much more complex families now. So maybe let's see if anybody recognizes this couple. This was Carol and Mike Brady, and each of them brought children in from a prior marriage. And so you had Jan and Cindy and Marcia with Carol, and you had the boys, let's see, I don't even remember their names anymore. And all of you can chime in and tell me on the chat their names. But in this situation, what you're trying to protect from is you're trying to make sure that the assets that were brought into the marriage are protected for those stepkids. So it might be that the estate splits upon the first death, and half of that is only to be used for the surviving spouse. And let's just pick on Mike, and let's say that he survived Carol as an architect. He went off to a convention and met a sweet young architect that wanted to come in and help him raise these kids. And we just want to make sure that Mike is not going to disinherit Marcia, Cindy, and I'm forgetting the other one's name. But anyway, we want to just protect the family so that the funds are there to take care of them and it goes the way that you want it to go. So that would be a situation in which it's a little bit more complex. These types of things are not as easily done going through probate, and it's a lot more expensive than just writing it into a trust. So let's see if you recognize this family. This was more of a short-lived program, Life Goes On, but it was the first representation of someone with special needs. Corky had Down syndrome in this show, and what we're talking about here is making sure that we accommodate within that trust need for a special needs trust beneficiary. And that happens more often than not now. People are on more government benefits for different reasons, whether it is a disability from birth or something that happened later in life. And you don't want to inherit something if it's going to knock you off a public benefit. And certainly, I have a daughter that had leukemia in her early 20s. And so I've made sure to put language in there that's going to protect her if she's not able to work full time, that she can still get her government benefit, but then my benefits won't go to pay for her medical insurance and pay for all the medical costs that might come up in the future. There's also another family here we can bring up. Modern family. This might be a situation where there's a large or a modest estate and you've got children from different marriages. So you have a younger generation and you have adult children that are well on their way. And there are going to be tax implications here. So you want to make sure that you go to an estate planning attorney that's got a background in tax, an LLM, that's going to take into consider estate planning issues that might come up with estate tax and that type of thing as well. And so there's I guess the reason I go through this is just to show you the flexibility. One of the other things that we are now able to provide for in the state of California is provide for our pets. And I'm doing a lot more provisions for pets in trusts. And in fact, my mother's dog, Roxy, is still alive. And she is benefiting from having some language in there that provided to give a donation to an organization that found a good home for her. I live in a high rise and I work too much, and I would have not been the best pet parent for my mom's dog, Roxy. So those are things that we can take into consideration. We can also take into consideration charitable intent. If you wanted to leave all your money to ElderHelp, or any other organizations such as Alzheimer's of San Diego, there's ways to capture that within a trust that are much more meaningful. You can even make gifts during your lifetime. If you talk with your estate planning attorney, they can educate you on that. You might want things to be kept in trust even if you do have healthy adult children because of their spendthrift ways or that type of thing. So the last thing I'll leave you with respect to trust is crisis benefit planning. A lot of what I do as an elder law attorney is around getting qualified for the PACE program, qualifying you for long-term care, for Medi-Cal to be able to pay for that cost if you are going to run out of money during your lifetime, and having specific language in your estate planning documents documents, both your power of attorney for healthcare, finance, and within the trust, would enable that person to be able to get you qualified for that benefit before you spend down all of your assets and put yourself in a situation where your quality of life is not going to be what it would have been if you could get onto the PACE program, for instance, much earlier. All right, so I'm just going to show this graphic so that you can see the trust keeps you out of probate. It takes the place of most of what happens in your will. And it also straddles this line between life and death. So it manages a lot of your assets and things that a power of attorney would manage. So if a plan is done properly, all of these documents work together. And on the person side of this, your will, as we talked about, allows for disposition of remains, but so does that advanced health care directive. And that's sort of how they all work together. So key trust benefits are avoiding probate, control even after you've passed away. You can protect kids, you can protect pets, you can protect those with disabilities, you can do tax planning, you can plan for your own long-term care needs. And it can help you to avoid, a trust will avoid Medi-Cal estate recovery if you do end up needing to spend everything you own. Your house is an exempt asset. You don't have to sell your home to be able to qualify for Medi-Cal. So it's important to have that in a trust, because if it isn't, the state can come back in a probate action and they can recover against any monies they paid for your care. So it's important, if you do own real estate and you live in California, please make sure that you talk to an attorney and get a trust in place. Don't try to write that one yourself or try to execute that one on your own. All right, so I'll just leave you with these thoughts and then we'll take some questions. We want to plan for the worst and hope for the best, right? If we do this planning now, we can make sure that we give our family a roadmap and we can take care of our pets. I just love this picture with the little doggy with the mask on because that is our new reality for a while. So if it's properly drafted, there are levers in the plan that we can get you qualified in a crisis if you need to qualify for government benefit, and we can protect your business income and your assets as well as your primary resident and your retirement assets. So keep that in mind. All right, so I will open it up to questions now, and just want to again thank ElderHelp for having me here today.
Well, thank you so much, Yvonne. That was a wonderful presentation. I know I definitely learned a lot, and thank you so much for sharing your story. It was very helpful to kind of understand how all of the pieces come together. Mm-hmm. Let's see if we have any questions coming in. So for those of you, if I didn't mention this before, I apologize. We will be sending a recorded version of this webinar to all of you, and we will also post it on ElderHelp's website in our webinar library on our Family Caregiver page. So yes, you'll be able to have it later or share it with others who maybe weren't able to participate live today. So that will be there. If you do have any other questions, we have a few minutes, so please feel free to type them in and we'll be happy to answer those now. Let's see. Okay, we do have one coming in, Yvonne. If we get a trust in place, do we still put a will in place?
Yes, there are different types of wills. A simple will would be one that does not have a trust as part of its plan. So it would actually designate where everything goes. If you do get a trust in place, a good estate plan will have what's called a pour over will. And if you think of a glass of water being the trust itself, and you think of the pitcher, the pour over is pouring into that glass of water. And why we have that is in case there are assets that we forgot about or didn't properly title into the name of the trust, and it ends up in your estate, we can then make sure to get those into the trust so that we can administer administer your estate the way that you want it administered.
Wonderful, thank you. One other question coming in, can you create a trust for a parent if you have power of attorney?
You can, but not from the statutory form. It is very specialized language, so it needs to be one of those levers that you pull in a plan, as I discussed. Even in a very robust plan with a revocable living trust, we want to put language in both the trust and in the power of attorney that would allow us to go back and do some asset protection and create another type of trust, which is called an irrevocable trust. If you just have a power of attorney, you're going to want to make sure that if that is something that needs to be done in the future, that you have the proper language just in that power of attorney to create a trust when none has been created before.
Okay,
did that answer
great.
their question? Do they have anything follow on? Let me know. I'll go into more detail if that wasn't clear.
So far, so good.
Okay.
Let's see if there's anything else. And you all have Yvonne's contact information as well. We'll be sure to share that in my follow-up email also. So if you do have any questions that you're maybe wanting to ask on a more private basis, you'll be able to do so. It looks like we do have one more question coming in. Do you put power of attorney in place now if your parent can still take care of themselves?
Okay, so I'm going to get on my soapbox right now and tell you that every adult age 18 and older must have 2 documents. If you don't have a will, you know, everybody's got an estate, right? You have something that's yours and you want to give to someone. A will is important, but the 2 most important documents in the entire plan are a power of attorney for finances and a power of attorney or advanced healthcare directive where you're naming an agent. When my kids went off to college, I made sure that they had someone named as their agent. And the reason that's important to do while you have capacity is there's no question that there is any validity issue with that document. So absolutely, even if you can still do things for yourself, you need to think about, contemplate, reflect, who is that person that you trust? And I can tell you, our plan has been rewritten a few times because now that our children are getting older, we're looking at them and saying, well, maybe we would trust them now with these things. When they were in their 20s, we were naming our siblings to take those jobs, right? Or even not old enough to be named if they weren't 18. So that is a very good question. Absolutely need to have it in place now. If you don't, the consequence is a conservatorship. And I can tell you, because I volunteered at our conservatorship clinic that is run by our court system as part of the Legal Aid Society manages that. And it's heartbreaking to see families coming in crisis and having to go through a court proceeding that I can tell you is not quick, and it's even slower during COVID, and it's expensive. So you do not want to have to go through that or put your family through that when they're in crisis. So please go get these documents, download the ones you can now, and get that done.
Wonderful, very good point. I think we all need to take that into consideration. Doesn't look like we have any other questions for the moment. I'm going to finish up a couple slides and then we will see if anybody else has any further questions. But again, thank you so much, Yvonne. I really appreciate your time with us today. And again, this recorded version will be available. So if anybody would like to share it with other members of their family or friends or coworkers, you're welcome to do so. I'll send the link to you as well. If you have any general questions about what resources might be available, or if you're looking for yourself or your loved ones for other information, and we are happy to help you and point you in the right direction. So please reach out to ElderHelp If you would like to be notified of all upcoming family caregiver webinars through our series, please let me know directly. You should have my email address, but it's here on the screen as well, and I'd be happy to add you to that list so that you get access to all of those as they come out. And then we do have a newsletter for ElderHelp that we send out every couple of weeks. So if you would like to stay connected and keep in touch with us that way, please feel free to sign up for that. And stay tuned for our August topic for our family caregiver webinar is in the works, and we will be sending that information out shortly. But again, thank you so much, Yvonne, for your time. It doesn't look like we have any other questions coming in, so I wish you all well, and thank you for joining us today, and hopefully we'll see you again soon.
Great. Thanks so much for having me today, Carrie. I really appreciate it, and good luck to all of you out there. Stay safe.